All right, let's get started. I see there are 38 of you in the room. Hopefully the rest will come in momentarily. If you could turn on your cameras if you're able to, I would appreciate it. Um, Good morning. My name is Josh Blackman. I've been teaching here at South Texas my ninth year at South Texas. You will not have me in the fall, but there's a pretty good chance you might have me at some point later in your law school career. I teach property and I teach constitutional law. I love doing the orientation because this is such an important part of every law student's process. You will learn so much over the next few months that this brief period gives you a little glimpse into what's ahead of you. What I'd like to do today is to address the elephant in the room, which is the fact that I'm not in front of you face to face like I would prefer to be. We are all on this awful grid system where we see people only on Zoom. This is all different from us. Second, I'd like to give you some general thoughts of how to prepare for 1L in general. Third, I want to actually give you a sample lesson. I gave you a reading. I hope you did it. If you didn't, you are in trouble because the amount of reading you'll have this semester will overwhelm you. And if you fall behind, it will be tough to catch up. And at the end, I'd like to take questions from you. Please be candid. I'd be happy to answer whatever questions you have. Yes, the reading about the fox, exactly. If for whatever reason I don't get to your question today, you can email me and we can set up a time to do a call, either on the phone or on Zoom. I'm happy to meet with you. Like many of you, I'm stuck at home. I can't go anywhere. So there's plenty of time to make our schedules meet. All right, so first, and I don't need to do a poll, show of hands, how many of you, just raise your hands, had to do Zoom in class last year? Or some sort of online learning? Just raise your hands. Actual hands. I'm not using blue hands. Yeah, that's so much better. Okay, I'm seeing a lot of hands go up. Okay, good. So you are generally familiar with how Zoom classes work, but I think you'll find in law class it's a little bit different. Law professors are much more engaged in asking questions. Some professors will call on a single person, maybe for 30 minutes at a time. Other professors may call on a student for 5 minutes at a time. Other professors call on a student for 1 minute. So you'll need to figure out how your professor asks questions very quickly. You'll learn soon enough, I promise. I think the second thing you have to keep in mind is motivation and focus. I think the hardest part of Zoom University is keeping yourself motivated. You don't have friends to poke you. You don't have study groups in person. If you do, don't tell us about those. I know they're going to happen, but just sit 6 feet apart, please. You're not going to have a professor there to motivate you. You'll have virtual office hours, but you won't have an actual office to hop into whenever you want to have a question. And there's something lost. But don't despair. I think we've spent a lot of time this summer thinking about how to revamp our teaching for this environment. You'll find that your professors put together a lot of supplemental material. There might be videos. There'll be more frequent what are called assessments, which basically means evaluations, quizzes for you. The goal of these sorts of assessments is to make sure you're not falling behind. When you're sitting here behind this glass screen, I have no idea where you are. And the goal is to make sure that you are always on top of things. So that's the general overview for Zoom University. I think you will adapt quickly enough, but it's going to be tough. Next, I'd like to talk about law school in general. And this is in no way limited to the fall of 2020. I would give the same advice to any class. I've been doing this now for some time. I compare law school to a marathon that's run at a sprint pace, right? Usually with a marathon, you can sort of just pace yourself and go along. Or if you're running a short race, you sprint and you go full speed, right? Law school is both. You start on day one, which I guess is Monday now, right? You start on day one at a full sprint. I assume you all have your readings. You all have your books. You'll find that you might have 20 or 30 pages of reading per class per day. You might have, in some busy weeks, 100 pages a week. You might have 200 pages a week. And what you'll find is that reading a law school case is not like reading, like a novel, right? That might be fun to read. The language here is painful. I picked the Fox case quite deliberately because it's written in a language that you're not going to understand. I know, so you're nodding. There are legal terms, right? There's terms in Latin. Who the hell knows Latin? I know who speaks Latin. No one speaks Latin, right? There are all these things like, what the heck are they talking about? So I'm telling you, if it takes you a page, say it takes you a minute to read a page in, whatever college textbook you have, it might take you 5 minutes to read a page, right? The PDF I sent you is what, like 7 or 8 pages long? That maybe took you an hour, right? Maybe longer. That is designed to give you a sense of how long this process will take you and how much it will matter. But it's not enough to just read for class, if only it were that simple. You have to do what's called outlining. Now, I think they've given you classes on how to prepare your outlines. I'll give you my own spin on this approach. Every student outlines a little bit differently, right? Every student outlines a little bit differently. What works for person A will not work for person B. People have different memories, have different ways of recalling facts. You'll need to find what works best for you. But if you have any doubt at the beginning of the semester, prefer to write more, not less. Make your outline longer, not shorter. You can always go back later and sort of tighten it up, but if you're ever in doubt, put more into it. So it may take you to read a 10-page case an hour. And if it takes you 10 pages for an hour, and you have 100 pages, that may be 10 hours of reading. If you have 200 pages, that's 20 hours of reading. So on top of being in class for 5 or 6 hours, well, you're not actually in a building, but on top of having 4 or 5 hours of class time a day in your apartments, you're still going to have to write a significant amount of notes. And then you have to get to class. And I'm not even talking about class yet. When you get to class, you're going to have what's called recitation. It's a funny word, but it means to recite a case or to go over your classes. And the first day, Professor X will say, Mrs. Smith, Mr. Jones, what are the facts of X, V, Y? And it's like a question that will just cut to your heart. It's like, oh my God, why me? Why am I first? Right? Why am I first? And you're going to have to give the facts. And no matter what facts you give, it's probably not what they're looking for. And even if it is, they'll still ask for something else. So it's like, well, but what about this? And what about that? And how does this affect it, right? And the purpose of these questions is sort of, pardon the phrase, tear you apart, right? It's trying to tear apart what you know and get to the actual legal premise. Because the things you put in your outline are probably not the most important things. You'll learn this over time. You don't know what's important in a case. You just don't know. You'll figure that out when you get to class and the professor tells you. So the class participation, I'll be frank, it's going to be intimidating. And you're going to say, oh my God, I didn't read the case carefully enough. My notes aren't good enough. You'll get better, right? As you go through your first semester, you'll start to figure out what works and what doesn't, what kind of notes help you, what don't. Don't be afraid if you come to the first day of class and you did your hardest and you don't know. Professors know, right? We know the difference between a person who tried and didn't get it versus a person who just didn't try, right? It's really obvious to us which is which. So if you did your homework and you really worked hard and you don't know, it's okay. That's not the end of the world. You'll find your path. You'll find your footing. All right. Now let me give you the other side. I have so far described the student who's diligent, who's hardworking, who's ready for class. There are now about 40 of you in this room. I'd say 10% of you will not be prepared for the first day of class. I'm just going based on past experience. I don't know who you are, but it's inevitable that in any given class, about 10% are just not prepared. Now there are circumstances, there's stuff going on in the world, I get that, but professors will figure it out really quickly. So let me now speak to the students who may not be fully prepared for class on Monday and for class on Wednesday. You may be tempted to take shortcuts. What is a shortcut? Well, maybe your friend had Professor Jones last year, and they give you his outline, right? His old outline. Don't use them. It is a crutch. The benefit of an outline is not actually having it. The benefit of the outline is creating it, right? By creating the outline, you are learning, you are drilling the facts into your head, you're thinking about it. If you just download some friend's old outline, you are cheating yourself in really bad ways. And you won't know it till you hit the midterm. That's when you're gonna realize it. You get to the midterm, like, oh boy, I don't know what the heck I'm doing. So don't download your friend's old outline. I know some of you will. I'm sure some of you already have them because professors tend to teach the same class year after year. But for your own sake, I would not recommend you do that. The second shortcut, by the way, I know the dean had you sign these 1L commitments. Remember these things? He made you, I think, you handwrite them out. I think number three is don't take shortcuts. So don't take shortcuts. The second shortcut you should really avoid are what are called commercial outlines or supplements or horn books or treatises. There's a million names for them, right? These are books you can buy, in the bookstore, on Amazon, wherever you buy them, that summarize the law for you, right? Maybe there'll be an outline of a case. They'll give you the summary of a case. Or maybe it'll summarize doctrine, torts or crim law or contracts, whatever it is. I beg of you, for first semester, don't use them. Please, you're going to hurt yourself if you use them. Second semester, maybe consider them. But in the first semester, you will become dependent upon them. You will not know how to figure stuff out for yourself if you rely on these supplements, these outside materials. And again, you won't know this until you hit the midterm, because you can probably coast through class well enough with these supplements. It's entirely feasible, right? You could just fake it and sort of just get along, and maybe the professor doesn't have enough time to pick on you. But when you get to the midterm, it's going to be like, oh my God, what the hell? I don't know how to do anything myself. And at that point, I don't want to say it's too late, but it's getting to be too late. Because again, this is a marathon run at a sprint pace. If you get to the middle of the semester and you realize that the first 400 pages of the textbook you don't really know, good luck reviewing that in a week, right? Good luck trying to cram in 400 pages of reading in a short period of time, on top of your other homework assignments, your legal research and writing assignments, and all the other things you're going to have to do this year. Now, I'm not trying to put the fear of God in you, right? This is not my goal, is to scare the crap out of you, but my goal is to simply tell you what happens in the past. Now, about a year ago, maybe it was 2 years ago, I can't remember, I did this orientation in person with the Fox case, the same case I gave you. And I remember there was one student who walked in late. I don't remember his name. It doesn't really even matter who he was. You guys can't walk in late because you're all in your apartments, I suppose, right? But this guy walks in late. And I was like, okay, I know what to do here. So when I start my mock class, I call on him first. And I say, what are the facts of the case? And he starts bumbling. And I said, well, what happened on the beach? And he says something like, well, the fox ran away. We ran away. If the fox escaped. Like, he was just making something up about the fox on the beach. He obviously hadn't read it, right? And I was like, did you read the case? He's like, no. I said, why are you making this up? Why? He's like, oh, I don't know. Like, maybe that stuff works in undergrad. It's not going to work here. And I said, within 2 seconds, I said, all right, this kid doesn't know what he's doing. Whatever. And I think I made a point. I think I said this. I said something like, at the end of 1L, some of you will not be here, right? Because some of your grades will be below the threshold. And it happens every year. And the people who this happens to are those who don't work hard. If you work hard, you'll be fine, right? The people who don't make it are those who don't do the hard work. Well, I saw actually the same group of students at an event before we went on Corona leave. And one of the students told me that kid who came in late, wasn't prepared, didn't make it. He was no longer at South Texas. So I'm telling you, from the very get-go, I had this guy pinned within a minute of the class starting because he walked in late and didn't do his homework. The little things matter. And again, I don't remember his name. It doesn't even matter. I couldn't tell you who he was if I needed to. But within your cohort, your section of 80 or 90 people, handful probably won't be here next year. So don't let that be you, right? Don't take the shortcuts. If you do the hard work, you will be here. And you'll be on a pathway to success. But you need to do the hard work. I can't stress that enough. We can't do it for you. You have to do the work yourself. Motivation is going to be tricky this year. It really will. Precisely because you are all sitting in your own homes and apartments scattered throughout the country. Who knows where the heck you are. You won't have the same sort of social activity. So take advantage of what we give you. We'll have Zoom happy hours. That thing sounds like insane, but that's the world we live in now. We all sit looking at our 30 by 30 grids, like a little bingo board, right? But that's where we are. Okay, I'm going to stop scaring you, and I'll do the mock class in a bit. But I always like to give the one Ellis an opportunity to ask questions. So if you have a question, just now you can raise your blue hand, and I'll be happy to give you the floor. Are there any questions now about anything I've just said? Okay. Okay, good questions. Okay, so is that Caitlin Santibanez?
Yes, that's
Okay.
correct.
Okay, go ahead, Caitlin.
So my question is, I know you said don't use study aids, but is it not smart to do our own work and then check it with a study aid before we come to class?
I always get this question. Look, if your professor recommends you use something, I think you should probably listen to that, but be very careful. Be very careful about checking your work because it becomes a crutch very quickly. Um, if your professor gives you a specific approach using a supplement, then do what he or she says, but I would not on your own try it.
And waiting till we get to class to, I guess.
Yeah, ask questions. We love questions. And rather than checking in your supplement, what I'd recommend, Caitlin, is you email your professor and say, I have a question about X, Y, and Z. Can you make a time to meet with me? That's so much better. Because let me just put this a different way. More often than not, students don't know the right question to ask. I know that sounds really stupid, but you think you're asking about X when you're really asking about Y, right? So if you go to the treatise and look up X, it's not even going to give you what you need to know. And if you go to a question that, Josh, I don't know X, or no, Caitlin, it's not about this, it's about something else. Like, oh, that's what you're talking about. And then it clicks, right? It clicks instantly. So the problem with these books is that they're fixed, right? You're reading from a book and it's either there or not. So I would caution you, by your second semester, I will relax my guidance and I'll say, okay, you know the ropes a bit, you can do a little bit more. But at least your first semester, at least at the outset, try to, any questions you have, put to the professor. You don't have to pay extra, right? Your tuition's fixed. In other words, you don't you don't have to pay extra for office hours. Now that sounds stupid, but like you're paying for a valuable service, right? You have the stupid $30 supplement and you're paying for like a $30,000 tuition, right? Use the thing that actually you're paying for, right? Don't just use the, and again, I author a supplement. I publish one and I don't even like my students using that much, right? They're good for backup, but the first course should be talking to the professor, not the book that isn't even for your course. Does that make sense, Caitlin?
Thank you.
Yes. Okay. Alexandra, I think you're next.
Hi, so I have two questions.
Sure.
Actually. So as we all begin to prepare for the first day of class and we've been reading, when those readings don't include the case brief and some of it is just informational, how do you suggest we take notes? Do we just highlight, annotate, or are we writing down things that stick out to us?
Alexandra, are you talking about the notes that usually come after cases, or it's numbered or numbered lists like those?
Well, for example, in our criminal law reading, it starts we're supposed to just skim the introduction, but as I was skimming that, I'm like, okay, should I write down what a crime is or what
Yes.
the punishment?
Yes,
Like that?
yes. The shorter answer is some things in the book you're gonna have to know it.
Okay.
I don't know what skim is always a tricky word to use. I've used it before myself, and that means students tend to skip it. But let me answer your question more broadly. The average law school casebook has two big components, right? They have big cases and then little cases, right? Or big cases and notes, which are numbered. The students, for whatever reason, think that the only thing that matter are the big cases, and the little notes don't matter. And what I find is that whenever I ask a question about the notes, students are not prepared. So invariably, the stuff I tend to test on is in the notes because I know students aren't reading it. So just for your own well-being, don't fall into the trap of only reading the big cases. Also read the notes. Relatedly, opinions sometimes have a concurrence or a dissenting opinion, right? A concurrence is a justice who agrees with the majority but has a different perspective, and a dissent is someone who disagrees with the majority. You have to read the dissents. They're in the book for a reason, right? Often, this is going to blow your mind, the majority opinion is wrong. Sometimes your editor will put a case into the book to show why the majority is wrong, and the dissent gets it right. I just blew your minds, didn't I? Right? The mere fact that the majority is the majority doesn't mean it's right. And so sometimes you'll need to read the dissent that points at an error in the majority. So always be sure to read everything in your pages 1 through 20. You read page 1 through 20, take notes on page 1 through 20. It's frustrating when people skip the dissents, and then that's ground for testing. And your second question, Alexandra.
So then we'll come to class, we'll talk about these notes, and then we'll also take notes over what the professor ends up saying.
Yeah.
So then our outlines, when we pull from our notes, how do we know if we're missing something or a major concept to be included that'll be tested at the end of the semester?
Yeah, it's a good question. So when we say outline, there actually are two outlines, right? There's the outline you do at home, number one. And there's the outline you work on in class, number two. One of the skills you'll learn is how to merge the two, right? The professor in class is performing a function. He or she is identifying what's important, what you should know, what you should take away. So your home outline is always going to be longer than your class outline, right? Now you say, well, I'll just study for my class outline. Well, guess what? The professor can test you on stuff that they don't go over in class. It's not a requirement, right? If it's in the reading, it's fair game. The challenge is how to merge those two things, your home outline and your class outline. Now, some people do it different ways. Some people will just have two completely separate outlines. They'll have their notes from class at the top and the notes from home, the notes from home at the top and the notes from class at the bottom. Other people will mix and match, where they'll basically copy and paste, and they'll sort of do a Frankenstein, where they have everything about case Jones versus Smith in one place, Joe v. Doe in another place, right? I can't tell you the best way of doing your outline. Everyone has to figure out what works best for them. People will tell you, here's what I did, and it's always different. Some people handwrite notes, and I think there's some value to that, especially on Zoom. That way you're not switching tabs between Word and Zoom, going back and forth, which can be distracting. If you're taking notes by hand, it's actually quite natural. Some professors would ban laptops in class. Yeah, good luck with that now, right? So there's distractions. People look at their phones. They get a text message. Their dog jumps on their lap, right? They have noise in the background. So there are all these other things you have to worry about that are not our fault, but are the that we have to deal with. Okay. I think Veronica, you have a question, please.
Hi, yes. As I started the reading for a couple of classes, I noticed that the casebook does citations of precedent. What do we do with those? Do we have to go back and do a brief on that as well? How do we?
Yeah, that's a good question, Veronica. Thank you for asking that. So you'll learn about citations, and you may not even know what the hell a citation is. I didn't know what it was when I started law school. Citation's a way that you refer to old cases. So it might be, you might be reading a case from New York in the 1990s that cites a New Jersey case in the 1970s, right? And you're asking me, do I need to go read those other cases? I'm going to give you a modified answer. Generally not. You don't have to go brief those other cases, right, from scratch. But if you're reading a case that discusses some old precedent, you should know that precedent. In other words, you don't have to independently brief the old case, but you should know the discussion. So let's say you have a case that says there are three different standards, right? New York courts go one way, New Jersey courts go a second way, and Texas courts go a third way, right? And then we choose the Texas approach. Okay, that's good. You need to know what the Texas approach is, and you need to know why they didn't pick the New York and the New Jersey case. So what you'll need is self-contained. In other words, I don't think you need to go and pull up on Westlaw or Lexis the old case. I don't think it's necessary. But you'll need to know the discussion of that case and what's been assigned to you. Does that make sense, Veronica? Yes? Okay.
Sorry, it does. Thank you.
Okay, very good, very good. Any other questions before I actually start the thing you were here for, which is the mock class, which I'd be happy to do? Anyone else raise your hand? All right, well, we can start. The way I do class recitation is not particularly creative, but I go alphabetically. The reason why is I actually give everyone a single question. So person one gets one question, person two gets a second question. And that ensures that everyone is on call. Professors have random number generators. I just do it alphabetically. I think it's helpful when you're on Zoom if you know you're next. So if you open up the participants tab, we have A to Z. So usually, Alex, you're last, aren't you? But I'll go alphabetically first by first name. So, Alec Zork, you here?
Yep, I'm here.
Okay, Alec. All right, so let's start. Can you give me please the facts in Pierson versus Post?
Yes, so as far as I understood, the facts were you had a hunter who was hunting for a fox.
What was the hunter? What was the hunter's name?
The hunter was, oh god, I started mixing them up between the two.
I know you did.
Yeah, I'm so sorry. The hunter is Post.
Are you sure?
See, mixing it up again.
You have 50% chance of being right. All right. So,
I know. I'm sorry. I'm trying to pull up 5 different things right now on my screens. Should get the fossil.
it's not going to tell you. All right. Let me.
I was looking at that one. Sorry.
No, I know. Okay, Alec, that's fine. Let me intervene. So, he's right. I don't know if he guessed or he had in his notes, but he's right. Post is the hunter. Okay. And the other guy is Pierson. So, is that Alejandro? You here?
Yes.
Okay, so who's Pierson in this case? What does Pierson do?
My understanding is Pierson's the one who finished off the fox.
Finished off? What do you mean finished off? I think you're right, but it's like a video game term. What do you mean finish him off?
So my understanding is that the fox was injured and Post was in pursuit, and so then Pierson came in and sort of finished off the fox and just...
You're saying finished off. What do you mean finished off? Just say it out loud. I think I know what you're saying.
Killed it.
Killed it. Yeah. It's like finish it. Right? It's a video game term. Like
So many video games.
yeah. So he killed him, right? Okay. So you have Post is the hunter, and Pierson is the person who actually killed the fox. Okay. Now let me take a step back. Why am I making such a big deal about their names? Well, very often the professor will ask you, what did Post do? What did Pierson do? The case will say plaintiff and defendant. You need to figure out who is who, right? And I always start this mock class on its exact same point because this case is always confuses people. Like they keep saying plaintiff and defendant, who is who, right? You'll need to figure that out, and sometimes it's not obvious from the case. All right. Let me give you a tip of how you can figure this stuff out, right? This is going to be very helpful for you. The case is called Pierson v. Post, right? Pierson v. Post. Why does Pierson come first? And why does Post come second? You ever think about that? Think of the most famous case you want, right? Roe v. Wade, Brown v. Board of Education, whatever case you want, right? Why does one name come first and a second name come second? Anyone know? Yeah, Oliver. I'm just going by the order of the hands they jump up in. Oliver.
Yeah.
Why does Pierson's name come first and Post's name come second?
Because Pierson is the plaintiff and Post is the defendant.
Well, you're close, but what court are you in, Oliver?
Civil court. That's right.
No, not civil court. It's a civil court, but what level of the court are you in?
Supreme Court, right?
So did the case begin in the Supreme Court?
No, it would have begun in the district court and then move up to the. It would have been appealed and then moved up to the Supreme Court.
Okay. So Nadine, I think you're next on the list. Nadine, why is Pierson's name first in this Supreme Court?
Is he appealed?
He appealed. What does that mean to appeal?
So in the lower court, they ruled in favor of Post.
Exactly. And then, so who appealed?
So Pierson appealed.
Yes, perfect. Thank you all. You can all put your blue hands on. That's exactly right. In the first year of law school, you were going to be reading almost entirely decisions in appellate courts. Okay? In your first year of law school, you're reading decisions from appellate courts. You will read very few trial court decisions. So in any appellate case, someone prevailed, someone won in the lower court, and someone lost in the lower court. Usually, the party who loses will file an appeal. So in this case, Pierson lost in the lower court. And so he appealed. That's why his name comes first. And we know from the case that the person who lost in the lower court was the one who actually caught the fox. So the way you figure out who is who here is by looking at the names, which order they come in. You can actually figure it out that way. It's not obvious. I was kind of picking on Alex and Alejandro. I didn't mean to be unfair to them, but but there are tricks, right? And I use this simple thing to tell you that law school is a process, right? This is not something obvious that anyone will ever tell you. You can read this PDF and like, what the hell am I reading with this fox and the hunt? What am I reading, right? But there are certain things that you'll acquire along the way. Okay, everyone get that? Trust me, from now on, whenever you look at a case, you see X v Y. Oh, that means X lost in the lower court. You'll never forget that. In fact, the students I saw at the event who told me that the kid who got kicked out mentioned, like, yeah, we always know who X v Y is. So just, certain things that stick with you, that will stick with you. Okay, now we're on Alexandra M. Are you here, Alexandra M?
Yeah, I'm here. Hi.
Okay, all right. So we know so far that Post was the hunter, and Pierson was the sort of person who killed the fox. I call him the jerk because that just makes my life easier. Can you just walk us through what happened here? This is an unusual case, probably not like anything you've ever read before. Like, what was the beef between these two guys? What was going on here?
Okay, so if I'm being honest, I thought that the case that we had to brief for the Jackson v. Franklin Sports Gazette was for this. So
okay, all right.
I know, I just started reading the case for this class, so I don't think I can answer that well.
Oh, okay, all right. Alexandra T.
So my understanding was that Post had been pursuing this fox for a long duration of the time with other hunters, and then Pierson intervened at the end, killed the fox, and then had definition of occupancy because he obtained the fox at the end.
Okay, very good. Well, I think you're actually giving me the analysis, which is great. So, but Alexandra, let me just see if we can clarify the facts here, right?
Okay.
So Post is hunting the fox. You say he's doing it for a long time, right?
Yes.
Do you know how long he was hunting the fox for? Did the facts suggest actually how many hours or days he was actually hunting the fox for? No, be confident. You're right. It doesn't tell you, right? It just says he was doing it for some period of time. Okay, good. Now, Anthony, are you here? Anthony A?
Yes, I'm right here.
Okay, Anthony. So let me ask you a question, please. So we know that Post is hunting it. He's really putting a lot of effort into it. And then what happens kind of towards the end of the process?
Pierson comes in and kills the fox and takes it away as his own property.
So Anthony, what strikes you as potentially problematic about what happened here? Why is this problematic?
The fact that Post put in the effort to hunt the fox with the hounds and put in all the effort when Pierson just comes in at the end to pretty much claim the kill and the prize.
Yeah, no, you're right. But my question is, why is that problematic? So what? Why is that a bad thing? I think you described the facts accurately, but so what? Why is that something that you go to court over?
Well, Post went to court over it because he felt that the fox was his property because he was pursuing it.
Well, right, but why is what Pierson did so bad? I'm asking this question. You're dodging it, right? Why is what Pierson did such a bad thing? You're fighting it. I know you know the answer. You just don't want to say it.
My guess would be he just took it from him and just.
And how would you describe that? Let's just say I have young toddlers at home, right? How do kids describe it when things like this happen? What's the word they use?
Just the jerk. That was a.
Yeah, but you take something from a kid. What's the kid going to say back to you?
Unfair.
Fair. Oh, there it is. Thank you. Okay, you were fighting it. It's unfair, right? Thank you, Anthony. The reason why this case is so popular, it's in every law school class. If you talk to any of your friends at their law schools, Ask him, did you do the fox case? Yes, we did the fox case, right? Every law student in the world reads this case. This case is in every book because it goes to a very basic point, which is fairness. It's not fair. It's not fair that I spent all this time hunting this damn fox and this jerk at the last minute comes along and swipes it from me. I put in all this work. Why is he profiting from it, right? I spent hours here hunting with my dogs and my guns and cornering this fox. And this jerk comes in at the last minute. All right, everyone see that. So Brian W., you here?
Yes.
So Brian, do you think this situation is fair or unfair?
I think it's generally unfair.
Okay, tell me why.
Well, our appellee post here was chasing the fox.
Oh, actually, yeah. Go ahead, appellee. Go on, yeah. And just wait, appellee. Let me just make sure to clarify the terminology. There's a word he said that's important. You have appellee and appellant. I'll type them in the chat because you may not be familiar with these words. Appellant and appellee. Appellant and appellee. The appellant is the person who appeals, right? It's the person who files the appeal. In this case, the appellant is Pierson because his name comes first, right? Pierson is the appellant. Post is the appellee. And you know this because the Pierson name comes first. He's one who appealed. He lost below. And Post's name comes second. He was the one who didn't appeal. He prevailed below. He's the appellee. And it's pronounced appellee or appellee. You hear it both ways. Doesn't matter. All right. Brian, I didn't mean to interrupt you, but you used a good word, and I wanted to make sure your classmates knew about it.
Good. All right. So he was in pursuit of the fox, and my understanding from reading it was that Pierson knew that he was in pursuit of the fox, jumped into the hunt and killed it on his own.
Yeah.
Because I'm not real familiar with 1800s law, but
It's okay.
But it seemed that since they were on a lot, like a unimproved, uninhabited lot,
Good.
that being in pursuit of that fox made it his property and therefore a trespass.
Brian, were they on public land or private land?
I believe it was public land.
You're right. It was public property, which actually makes a difference. And you'll learn this later in your studies. But when you're on private property, you can't just go around killing people's foxes, right? So this was on public property that no one owned. It was basically a beach. Okay. All right. Is Christian? Are you here, Christian? Christian C.
Yes, sir. I'm here.
Okay, Christian. So we already heard one side that this was unfair to Post, the hunter. Give me the best defense you have of Pierson, the jerk. You're his lawyer,
well,
right? What's the best defense for him?
I would say since it's public property, and that even though Post was already hunting it, due to being public property, he kind of has the right to kill the fox as well.
Okay, but that's a good argument. But how do you respond to the claim that's unfair? What's your response to that? Because look, they were both in public property, right? But so what? How do you respond to the claim that was unfair?
I would say, if you're in the hunt of the fox and you haven't killed it, but, I'm hunting it just as well and I can kill it, then I killed it before you,
So you're saying it doesn't matter how much time you put into it, it's whoever does the final act is what matters?
Yeah. Yes, sir.
Now, let me ask you just one follow-up question, Christian. If you're the one who actually kills it, what do you actually have to show for it?
What do you mean by what do you have to show for it?
If you're the one who kills the fox, what do you actually get?
I guess you would get to keep it, or you would have the bragging rights saying that you killed it.
Yeah, you get to actually keep the fox. And there's an important point to think about, evidence, right? How do you know how long Post was actually hunting it? Do you have any idea? An hour, 2 hours, 5 hours? You could have just been making it up. You could have been lying, right? The only evidence we have in this case is the damn fox, right? The fur. And that's evidence that he actually got it. All right. So I think you've both given me the two different positions. Let me go to Dylan. Dylan, you here?
Yes,
Dylan?
sir.
So Dylan, we have a majority and a dissent. Who wrote the majority opinion? Which justice?
The majority opinion was written by Tompkins.
Okay, very good. What did the majority hold in this case? Who did the majority rule for?
They ruled in favor of Post.
Okay, tell me why.
I believe it came down to the fact that although it didn't seem fair, he didn't legally do anything wrong.
Okay, so you think the majority ruled for Post, the hunter?
Oh, I'm sorry, for Pierson.
There we go. See, the names matter, and I let you hang for just a second to make people nervous. Sorry, it's mean, but the names matter, right? So again, so just one more time, Christian. So what did the majority rule? Just so people have it clear for their notes.
Tompkins ruled in the majority, saying that although it was unfair, he didn't do anything illegal.
So what is the measure according to the majority, Dylan? What does it actually mean to get to acquire the fox? What actually has to happen?
I think you have to be the one to have hurt it or disrupted its natural liberty.
Perfect. And that requires doing what to the fox? What do you have to do to the fox? What did Pierson do that Post did not do?
Kill it.
And what does it mean to kill it? There's a specific thing you have to do with your body.
Oh, you have to physically...
That's it. Physically seize it, right. The thank you so much, Dylan. Appreciate it. The majority explains that when you want to capture a wild animal, you have to deprive it of its natural liberty, which is like this sort of funny phrase. But at its most basic level, that means you have to touch it, capture it. Now, maybe you can capture it with a spear or a net or a rifle, but you have to make physical contact with it. Post spent all this time chasing the fox, but he never actually got it. Pierson kind of just showed up, and he was able to touch it at the last minute. And the majority says, yeah, this isn't fair, but the rule, right? The rule of the case is that to acquire a wild animal, you have to physically touch it. You have to physically capture it. So if I were to ask you, Mr. So-and-so, what's the holding of the case, you say just that to acquire a wild animal, you have to physically touch it, right? Now, you'll see quickly that the rule isn't so neat and clean because you can use traps, you can use a net, you can use a rifle, which means not with your fingers touching it, but with other devices. This is one reason why horn books are not very helpful for you. Because if you buy a treatise that says the black letter law rule is to acquire an animal, you have to physically capture it. Okay. Then professor says, what about a net? What about a rifle? It's like, oh, wait a minute, that's an exception. So the reason why the cases are so important is you realize that the rules are never quite as clear as you think they are. All right. I have next to my list Emma. Are you here, Emma? Emma T?
Hi, that's me.
Okay, Emma, thank you. Emma, what did the dissent say? First off, who wrote the dissent?
The dissent was written by Livingston, I believe.
Yeah, good. Justice Livingston, okay. And tell me, what did the dissent say?
The dissent sided with Post because he thought that every hunter should know that he just thought that it was unfair. Every hunter should know that if you put in the work. He talks a lot about how anyone who was like a votary of Diana, which is like any hunter, basically, like he refers a lot to like the mythical things, but he also says eventually that there was another precedent established, which is something about like depending on which dogs you chased the fox with, then you should get to have the fox, even if you didn't end up shooting it and killing it.
Very good, Emma. And Emma, could you tell he was being a little bit sarcastic? He was kind of like joking around. Did that come through to you when you read it?
Yeah, he seemed like he didn't think that this case should have been heard. He thought.
You're exactly right. So tell me, why do you think the case shouldn't be heard? How do you think this case should be resolved?
He believed that it should have been just settled between the two hunters, I believe. Like, it's sort of something that you should be able to settle outside of court.
Yes. Okay, thank you so much, Emma. That was very good. The dissent was almost like, he was almost like joking around. Like, this case is stupid, right? Why are we wasting our time with this stupid case? These are hunters. Let them deal with it themselves. Don't waste our time with this, right? I'm sure there's some hunters in this room, right? And I'm sure you have disputes when you go hunting and you sort of just figure it out and you deal with it on your own. You don't go to court over it. Now, Emma said that the court cited mythical stuff, right? If only we're mythical. In law, this is real, right? They cite all these old writers, philosophers, like Barbarac, right? And Pufendorf, which sounds like a Harry Potter school. But these are philosophers of natural law. And my friends, you will need to know these names. Unfortunately, these are not just like, King Arthur, right? These are actual people that you'll need to know. But the dissent adopts a rule that says you can acquire a wild animal without physical touching, right? If you put in enough labor, enough work, you can actually obtain possession of the fox. So the dissent adopts this rule that physical touching is not necessary. And the majority adopts the rule that the physical touching is necessary. All right, so what do you take away from this case? I think what you take away from this case is to capture wild animals, you have to physically touch it. Now, if only the rule were that simple, right? Because you have discussion on nets and guns, right? Are you on public property or private property, right? Does the animal belong to someone or not? And wait, animals, which are living, are treated differently than stuff you find in the street. If you find a package of money on the street, is it treated like a wild animal? First person that touches it keeps it? So you see very quickly in law school that what starts off as a very simple case about foxes branches out into many different combinations. Again, you will not take property again until your second semester, so you can forget about this for now. Maybe you shouldn't forget, but you don't have to think about it right away. But what I hope that this exercise has demonstrated to you is how important the reading is, right? Knowing who the parties are really matters, right? Knowing what the majority held versus the dissent held really matters. Knowing what the rule is from the majority and what the rule is from the dissent, these things really do matter. Okay, and I appreciate the first, 10 or 15 people. Look, I called on, let me just count. Let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9. I called on 10 people in about 15 minutes. So you can see how quick I go, right? I can call on about 40 or 50 people in a class. So virtually your entire section's on call any given day, which means you are always on call unless the professor says you're not. And you can always be called on at any given point, especially on Zoom, because I think we're going to have to be much more aggressive with class participation. Because if you start falling asleep with your camera off, I don't know about it until I call on you. All right, I mean, I can only see so many faces at once on this stupid grid, and a bunch of you have your cameras off. It's a tricky thing with cameras, and I'll mention this point here. We had a discussion this in the faculty about whether cameras should be required to be on, and I think there's two schools of thought. One is when you have your camera on, I can see you, and you have to be physically looking like you're paying attention. It probably helps with focus. On the other hand, not everyone's in an environment where it's possible to have their cameras on. Some students live in a small apartment, and the only place there's quiet is in the closet or in a bathroom even, and they don't want to be sitting on the toilet with their laptop, right? And I get that. I mean, I'm sympathetic to that argument. So my policy would be cameras on unless you have a reason not to. Some people have bandwidth issues. Oh, this is a good tip. If you have very crappy Wi-Fi, which a lot of us do now, you can actually call into Zoom on your phone, actually dial a phone number. And you can just watch it on Zoom, but call in on your, put your earpods in, right? If you don't have that number, ask a professor. Every Zoom account comes with a phone number. So that way you can, even if your Wi-Fi knocks you off, you can just keep listening. And that, it minimizes disruptions. That's what I'll do in my class. Okay. We have about 10 minutes left until the end of the session. If you have questions, please raise your hand. I'll be happy to answer them. And if we don't get to everyone, I'll be happy to. All right. Trip has a question in the chat. Can you go over why or why not courts should even be in the business of studying hunting disputes? It's a good question. What you'll find is in the law is that people are often unhappy, right? If everyone's happy, they don't go to court. They resolve it themselves. But if people are really unhappy, they go to court. And when people have disputes, courts generally have to resolve them, right? If someone trips on your property, right? If someone makes a contract that they break, these are issues that are disputes, right? People go to court precisely because they have disputes. Again, every court case you read about will be where someone's angry at someone else. That's just the way our legal system works. Okay, thank you for that, Trip. Brian, I see your blue hand is up.
So we talked about earlier in the week how the judge's rulings become common law and the Supreme Court ruling has to be mandatory authority to the lower courts. So what's the purpose of the dissenting opinion in that aspect? Does it allow for a gray area there, or is it just sort of so everyone knows, like, oh, hey, this guy didn't agree?
Sure. So the question is, why bother with a dissent? And there's a couple reasons, right? In some situations, the dissent today becomes majority opinion in the future. Courts do reverse themselves. It's not set in stone. Second, very often the majority will reach maybe one or two issues, but there's a third issue the majority does not reach. And the dissent says, look, there's this third issue that's still lurking, and that might be something for a future case. Third, very often the majority has errors. And as law students, you should recognize where a majority makes a mistake. Okay. Nadine writes in the chat, an appellee can also be referred to as respondent. Yes. What you'll find in law is there's often many ways of saying the same thing. So often an appellant can be called a petitioner, and an appellee can be called a respondent. And the short answer is depends what kind of court proceeding you're in. In some court proceedings, petitioner, respondent. In other proceedings, it's appellant, appellee. It really varies by court. It's so much frustrating. Sylvia, I see your hand is up.
Yes, thank you. I had a question of clarification regarding Tompkins. And I heard you when you said that, like, the takeaway of his opinion, majority opinion, was that to capture a wild animal, you must physically touch it. But in my notes, the way that I read it was Tompkins was agreeing with Barbarak's argument that that you, not in all cases do you have to have this, bodily seizure, that it's not indispensable to acquire the right. And so I heard, and then in the dissenting opinion, I also read Livingston agreeing with that, so that they were kind of coinciding in that point. Am I mistaken?
No, you're right.
Reading that, or
You're right. And I think what you'll find, Sylvia, is when you try to reduce a case to a single sentence, you leave some stuff out. In other words, when you try and describe a holding in one word or one sentence, you omit stuff. So I didn't even get to Barbarak and the other guys, but you're exactly right in this case. There was some ground of agreement between the majority and the dissent, right, about whether there might be some cases where physical capture is not necessary. They didn't exactly say what that even was. Mm-hmm. But you're exactly right. Good point. Thank you. I see some questions in the chat, and then Alec, you're on deck. Ryan asks, how often will cases have minimal details in the facts? Very often. Sometimes the dissent has a fact, the majority doesn't, and you can presume that fact is correct. I mean, you're going to have situations where a dissent makes stuff up, but that's pretty rare. I don't think you'll see that. Clint, asks, what does the red text in square brackets mean? With the little stars? Those are the page numbers. Those are the page numbers, right? The PDF I gave you is just, a copy and paste from an actual document. But you have these books called reporters, these big books. And let's say you have volume 25 of the reporter. Okay, from volume 25, you flip to page 181, right? The citations are giving you the volume number as well as the, the volume number. Okay, so let me just show you. If you go to the PDF, right, You see it says at the top, Pierson v. Post, Supreme Court of Judicature, August 1805. That says 3 Canes 175, right? What the hell is 3 Canes? Canes was the name of a reporter. This was actually a person who published cases, right? That was his business. He published cases. What is 3 Canes? This was the 3rd volumes of Keynes's reports. So you have volume 1, volume 2, volume 3. And then it says 175. So this was page 175 of the 3rd volume of Keynes's reports. So it starts on 175, and then your opinion actually begins at 177. There's some other material I cut out. So you have 177, you scroll down, goes to 178, right? And 180 is where the dissent begins. So if I tell you the dissent is at 3 Keynes 180, you know that's volume 3, page 180 of Keynes. It's actually a very useful way of tracking stuff down. Okay, thank you. Okay, so Eteria asked, the case talks about rationing solely. I hope some of you actually looked up what rationing solely was. Rationing solely is a doctrine that says you own the wild animals that's on your property. Generally, if you have a farm and there's a fox running across your farm, that's your fox. But this was not on any private property, it was on a beach. Okay, Alec Z, I see you have a question. I think you have a question.
Yes, sorry about that. So my question actually was kind of similar to Sylvia's regarding how both the majority and dissenting opinions use Barber Act. But I guess kind of a step further into it is Barber Act, when they're using Barber Act in the case, it almost seems like both the majority and the dissenting opinions are using the same points for their cases, essentially. And I guess with the question number 3, it asks which one do you find more persuasive? And is it, I guess my question is it common to have cases like this where essentially, I know you're going to essentially using the same precedents or whatever, same legal theory behind, regardless of if it's majority or dissenting, but is it so common to where majority and dissenting are using essentially the exact same points, but just in a slightly different way?
Yeah, it's very common actually. What you're going to find in law school is that you have a precedent, you have a case, you have an authority, right? And the majority looks at this authority one way, and the dissent looks at the authority the exact opposite way. And say, oh my God, how can these 2 people who are very smart, these 2 smart lawyer judges, see the same authority different ways? Welcome to the world, right? We all come to this world with different, ways of looking at things, right? There are 40 of you in this room, and probably get 40 different opinions on any given topic. That's just the way law school, I think, functions. So it's really, Alec, not surprising at all to see the exact same authority being read 2 different ways. It's not surprising at all. All right, Sherelle asks, in a time when slavery was so legal, was it important to distinguish between wild animals and runaway chattel? I imagine this gets sticky in this period. Yeah, that's one way. Sticky is one way of describing it. You'll take constitutional law, I guess your 3rd semester, and you'll probably do cases fairly early on involving slavery and runaway slaves. I don't know that the Pierson v. Post doctrine applied in that context, but there were similar legal doctrines involving runaway slaves. So I think you'll say that in common law, probably not property, but very good question. I think I have time for one more question. Anyone else want to put a blue hand up, please? I have about a minute left. I wish you good luck. You will all have a lot of work. Oliver, Oliver, if you want to jump in there, go quick.
Yeah, and this isn't a question. Can you all hear me?
Yeah, we hear you.
Okay, this isn't a question about the case or anything like that, but this is more of a question to you. I've just been asking this question to other law professors, and I'm curious to know what your answer is. What's your favorite legal movie? Like a movie that focuses on like lawyers and law and all that.
So the obvious answer is To Kill a Mockingbird, which I won't say, but even better is My Cousin Vinny.
Yeah, same. I've seen that movie with my cousin, and it's hilarious.
It's perfect. And I'm from New York, so it's a perfect movie. It's just every single scene in that movie is perfect. All right. I think that's a high point. I'm done. If you have other questions, I'll put my email in the chat, and you can email me or set up a time. Happy to talk. But you'll do great if you do the hard work. If you don't do the hard work, you'll be in trouble. So I'll leave you with that. Thank you. Thank you, everyone. Thank you. All right. I think you're on to your next session. So oh, you have lunch now, right? All right. Well, I will not keep you from lunch. That would be a really bad idea. All right. Take care, everyone. Bye-bye.